the virtual hearings or the physical hearings or a hybrid mix of the two? What's your go-to model? Can technology have a positive role in reducing pendency? Guess the answer is yes. Or no, there are also cons as well. What's the big question, right? Highlighting the advantages of e-trials, all of this discussion, ladies and gentlemen, will be moderated by Ila Kapoor, the partner, Shardul, Amarchand, Mangaldas. Well, to talk about Ila, she specializes, shortly you'll be seeing her on the screen, specializes in both foreign-seated and domestic arbitrations. And Ila is a member of various coveted associations, including the New York Bar Association, the Commercial Bar Association, and also the IAF. Well, warm welcome to you, Ila. Thank you for greeting us with a lovely smile. Allow me to also introduce the panelists whom you would be, the discussion with whom you'll be moderating. So with that, welcoming and warmly welcoming Dr. Sanjeev Gemawat, the Executive Director, Legal and Group Company Secretary from the Dalmia, Bharat Group. Well, to talk about Dr. Gemawat, a general counsel and company secretary, a thought leader and a strategist with business orientation, 3 decades of experience for him across industries, be it automobiles, the real estate, the hospitality, manufacturing. He's also been associated in the past with DLF, JCB, GBC, and Modi Corp at the same time. So welcoming you as well. And with that, allow us to warmly welcome Samir Hossain, the General Manager Legal from Aditya Birla Finance. Samir is additionally responsible for the legal function of Aditya Birla Capital's Stress JV Asset Platform, debt syndication, debt capital markets, and is involved in the high-stake matters of the Aditya Birla Group with 15 years of experience for you, Samir. We are all set to have some amazing and worthwhile insights. With that, allow me to also warmly welcome Rajiv Chandan, the General Counsel and Company Secretary from Tata Chemicals. Well, Rajiv heads the legal, the company secretarial and corporate governance functions at Tata Chemicals. It's 25 years of experience for you, Rajiv, in the areas of legal, company secretarial, corporate laws, so on and so forth. Well, thank you to you as well for joining us. And with that, also we will be welcoming Sujeet Jain, the Chief Legal Officer from UltraTech Cement. Well, Sujeet, for you, yes, I would say for you, it's been 2 decades of experience, right, for working in organizations, say in telecom, the sectors being telecom, media, technology, in the leadership and the senior management roles. And prior to this, you've worked with Viacom 18 Media, and as a group general counsel and company secretary. And of course, you've witnessed the company's multi-fold growth journey. Very, very happy to have you on the panel. With that, ladies and gentlemen, we can extend some greetings, you in the form of comments and tweets, and I, of course, verbally. Let's welcome Sidharth, Sethi, partner, Sagar Associates. Well, Sidharth covers diverse areas, be it commercial litigation, insolvency proceedings, before the National Company Law Tribunal, arbitration, so on and so forth, especially focusing on the white-collar crimes, corporate and forensic investigation. Warm welcome to you, Sidharth. And with that, also allow me to welcome Abhai Pandey, partner, LexOrbis. Abhai, hi to you, and you lead the firm's dispute resolution practice. You, with a razor-sharp focus on the contested proceedings at trademark and patent offices, IP litigation, criminal enforcement. Your clients range from, say, Fortune 500 companies to individual entrepreneurs, say from the fashion, media and entertainment, publishing, FMCG, biotechnology industry, right? So that's very fascinating to note. Ladies and gentlemen, before I hand it over to our diligent moderator for this session, allow me to also express on behalf of Legal Era a big thank you to the session sponsor, that's Shardul, Amarchand, Mangaldas and LexOrbis. Ila, with that, it's all over to you. Welcome.
Thank you. And thank you to Legal Era. And good afternoon to everyone who's watching and to all our panelists. And thank you for coming out this afternoon to join this session. We're going to talk a little bit about e-courts and virtual hearing. Now, as practicing lawyers, we've had so many sessions about this over the last year and a half. But I think the interesting thing today will be to get an insight into really what our clients think about this change in our dispute system. We have over here today people who are engaged with high stakes litigation and arbitration on a routine basis. So we really want to know, how the last year and a half has been for you. We know that the pandemic has caused this fundamental shift in the way we look at disputes, in the way we deal with our counsel, in the way our counsel deal with courts. So with that, I'm going to open up the discussion and maybe begin with just asking Dr. Sanjeev with what your experience has been in the last year and a half with virtual hearings in terms of either a litigation or an arbitration.
Would like to thank Legal Era for inviting me to share my views. Ila, interesting question. The experience has been great, I would say. Experience has been great. For the simple reason that, yes, despite of initial apprehensions, particularly in the case of arbitrations where the cross-examination is going on or where the arguments are going on, initially you think that whether we would be as effective as we are normally in the physical hearings. But the experience was really different. Even in as far as the court proceedings are concerned, I would say that the way in which the things are progressing, technology is getting improved, the things are becoming better. At a given point of time, particularly for organizations who are having multiple litigations in multiple courts, you can address multiple issues at the same time. So to that extent, as far as the management of litigation is concerned, I think there's a lot of efficiency and effectiveness as far as general counsel's function is concerned. Because normally if the general counsel is sitting in a headquarter, it's difficult at times to manage multiple litigations. You are, dependent on external lawyers at times. You are, dependent on some other people as well. But then in a situation like this, in a virtual court kind of model, I think that you can supervise that in much more effective manner. But then I would largely say that, as I said that the experience has been great, but then I'm seeing this experience in multiple dimensions as well. As a chartered accountant, I remember those days that when we used to have the manual accounting, when the computers came, it was a big change for all of us in terms of shifting from manual accounting to computer-based accounting. And then there were multiple softwares and all that. With the all advancement in technology, normally industry adapts to this, professionals adapt to this, and this is bound to happen. This is bound to happen that the technology would keep on evolving, and so are the processes, and professionals would keep on evolving. And so from that perspective, it doesn't appear to me as something extraordinary. It's altogether a different thing that because of COVID kind of situation, perhaps certain things happen quite fast. But then it's not that these recommendations were not happening for the last 10, 15 years. I still remember, I think the Law Commission in way back in 2008 also recommended in terms of the use of technology. And the reasons were obvious, and it's not that we are using it this time. Various jurisdictions have adopted the mechanism, the processes for virtual hearings, for e-court filing, etc., for the last number of years, and there are some of the best kind of systems and processes that got evolved. So I think it's bound to happen. Largely, things have been good. There were certain technical glitches which we normally, say in terms of that it should not have happened. We were, kept out of this. We were not allowed to mention. The screen was off. These are some of the aberrations which happens even in the physical hearing. Also, one or the other glitches happen. So this is that kind of situation. I don't think that those are extraordinary. These are small aberrations which can be addressed with the advancement of technology. So in my initial comment, I would like to limit it, this way only. Thank you.
Thanks, Sanjeev. Samir, let me ask you, do you think there's a perceived psychological impact which prefers a physical hearing over a virtual hearing? Like as a client, if you enter a courtroom, there is just that aura of majesty about it, which you don't have sitting in a virtual chat room. So what do you feel as a client, as in-house counsel?
Yeah, so there are two aspects to it. One is obviously what happens within the corporate, and second is what is happening during the proceeding. See, I remember when IBC came in, and before that the New Companies Act came in, we did a lot of relearning in terms of how do we proceed our matters. I think that same relearning is now happening in terms of what is happening in court, because a lot of the counsels who were effective more in a live court are not as effective virtually. Or some people who are not as effective, in a live court are more effective virtually. So I have seen a lot of change in terms of strategy on who is chosen as a counsel and who is more effective. See, if you see the first part of the pandemic, some of the counsels were not even comfortable to have a junior with them when an argument was happening. So a lot of the arguments which were more related to art of advocacy in terms of body language, facial expression between the bar and the bench, the communication, I think those things have become less relevant is what I feel. The other thing I have noticed is the number of orders in a complex matter or a matter which involves a lot of separate proceedings heard together have reduced. Getting an interim order is a lot more easier. I'm comparing like to like in a normal physical court. So I think in complex matters, the number of orders are coming less than what it used to come in a hearing, maybe because of the complexity, though things are improving from the original phase. That may also be because of, a lot of disturbance, as Dr. Sanjeev was mentioning. In a lot of times hearing, there's a bandwidth issue on one lawyer side, the network is not available and all those things. But definitely in complex matters, I don't think it is still at par with physical hearing. But the benefits of having online hearing is too high if you compare that with the physical hearing. Because as again Dr. Sanjeev was mentioning, now today if there are 5 hearings, we can attend to all 5, see what is happening. We can, at various places. If there are 5 conferences, we can attend to all 5 conferences. So there is a huge amount of contribution in-house lawyers are able to do, which they were unable to do in the past. And also in terms of in the past, somebody sitting behind passing a message was far more difficult than now to WhatsApp in the same WhatsApp group where the counsel and our solicitors are there. So the amount of contribution we can make, say something is evolving during a particular hearing, it is far more easier sitting with the papers, having everything on my hand, which is not possible in a court to do in an online hearing. So yes, there are downsides, particularly in very complex matters, but I do see overall a positive.
Thanks. And Samir and everyone, please just jump in if you have something to contribute. I don't want to keep this very, tightly disciplined or anything. So if you have anything to say, just feel free to jump in. I mean, let me take, you said that suddenly it's easier for you as in-house. So let me ask you or Rajiv or Sujeet just to tell us, because at some stage in the pandemic, we in fact, we have still not opened our office at Shardul, Amarchand. So we're not really meeting our clients physically. We're still meeting them virtually. And I personally don't see this as a problem, though I love meeting all of you. Maybe the client feels that they are not getting the bang for the buck, right? Because they're not physically meeting their lawyers. I mean, is that a perception among you?
So I actually feel it as a benefit that we are not meeting. So though our office is...
So it's a mutual thing then. We don't want to meet each other physically.
We are able to do far more meetings. I'll put it that way. It is far more efficient. It's a mutual thing.
No, the only downside, Ila, perhaps is, as far as our discipline is concerned, we have not been able to manage that discipline, because normally we are having meetings and conferences in odd hours. It starts at times at 7 o'clock and it goes till 11, 11:30, at times 12, 1 also. So we have not been able to manage that timing because of this whole arrangement for the last 1.5 years. Perhaps more discipline is required. But then I would certainly say that we have saved a lot of time in terms of commuting from one place to another, and also the kind, when I say that the efficiency and effectiveness have increased manifold, believe me, if I'm attending a matter in Karnataka, having a conference in Karnataka at the same time in Rajasthan and at the same time in Odisha, it is such a flexible kind of situation. So the only downside has been, yes, we have not been able to manage discipline, but then that is our problem. But then from a technological standpoint, I think it's a revolutionary step. And I think in the times to come, this would certainly help in terms of a very, very high level of enriching justice delivery system or enhancing justice delivery system. It would have tremendous benefits in the times to come. And we can discuss that part also in, if we have time on that. Yeah.
Yeah,
Sure.
just wanted to, particularly in respect of the client meetings, the technology here, particularly this, the video conference, the video call tools which have been used so widely now, but international clients interaction has become much more easier, much more active. Earlier they used to have, we used to have a conference call, but now we meet over a video platform, and even the timing situation has also gone, because earlier used to be in offices and then there was some restricted time. Now we can at home at any point of time can speak with any client across anywhere in the world. And that too, seeing each face to face, at least on the virtual platform. So that has eased the client interaction much effectively in the last 1.5 years rather than. Yeah.
So right now, this is a really rosy picture. Is there a downside? Does anybody want to talk about what they feel the last 1.5 years the downside has been to virtual hearings?
I could just step in there, Ila.
Sure.
Now, and I will borrow from Dr. Gemawat's words. He says it's revolutionary. These are minor aberrations, and I second him on that. I totally agree. But I will only point out some practical issues which we faced as lawyers, as practitioners, which you faced, I have faced, Abhai sitting here has faced. And these are minor aberrations, I must say. One major issue has been unreliability of technology. If the internet connection is unstable or is lost during a hearing, the right to be heard gets impacted, and this impedes our ability to effectively present your case.
Yes.
Because we are eventually presenting your case to the court.
Yes.
Now, sometimes during hearings, it gets difficult to pass on messages or confer with colleagues. Now, Samir mentioned that it's very easy, you are able to send messages on WhatsApp. So those are means we are trying to adopt to confer with our colleagues, but to get instructions from you and to immediately pass on those instructions to the senior counsel has been a bit of a challenge because the momentum gets broken. The other problem is a rather practical one. While many of us participate in hearings from a proper conference room or office, there are lawyers who are participating from locations which are not as conducive, and it leads to ambient noise and other disturbances. Yet another issue is with some platforms. We've all seen that, and I, being an advocate on record, I can talk about the Supreme Court platform. We've faced issues with that, and although it has seen many refinements since inception, many a times participants are simply removed from the room and not then allowed to join. Sometimes counsels are not even allowed to enter the hearing room, so this poses serious concerns. And if one does get entry, there are situations when counsel are not unmuted. And all these cumulatively give impetus to the sentiment that virtual hearings are not as effective. Fortunately, the judges are receptive and cognizant of these problems, and we as lawyers, attempts are being made to minimize these issues. We are experimenting with new platforms, we are training the staff, and requisite tweaks we are making. But these issues still remain. There are aberrations, no doubt, but these issues remain, and sometimes they lead to disastrous consequences. If a lawyer is not able to present his case and a stay is needed on that first day, and you're not even unmuted. So that's one thing which I wanted to add there.
Yes. So I just wanted to interrupt here, but Ila, what Sidharth is saying, these are the practical difficulties, and that's what I use the word, the technical glitches are there. The one major problem in this is that different courts are functioning on different platforms, and those different platforms are not effective. I have seen that at times the district courts platforms are more effective than the Supreme Court's platform. or some other high courts platform. So I think one is the different platforms are being used by different courts, and I think that is one major problem, and there the technology perhaps is not appropriate. I second what Sidharth is saying, that yes, there are practical difficulties at times in terms of one or the other issues, whereby the cases have not been heard properly, the main arguing counsel have not been unmuted, he has not been allowed entry, or at the last moment when the matter is just coming up, the main arguing counsel has been exited from the room. So these things happen. We have all suffered on this. But then on a larger platform, if I analyze these, then I see that yes, these are the experiences, downsides, negative experiences. But then can that be addressed? Perhaps answer is yes. With the technological changes, we can address that. But then the benefits are so large that these aberrations, at times we ignore these aberrations, that yes, these would happen in a new initial phase of any technological change. These things happen, and with slight training, discipline, or use of technology, or a better technology, perhaps we may address those issues.
Birla, can I pitch in, Rajiv?
Yes, please, Rajiv.
Yeah, in fact, my experience, of this is that it's fantastic. Yes, this is something which has been, it is kind of an imposition by a pandemic on us. So it is not a properly laid down system we are experiencing. This is an arrangement which happened over a period of time. But my point is that we should try to convert this into a proper system which can work alternatively to the physical courts. I think this is an opportunity which has come in our way, where if you see the judicial infrastructure in this country is not that great. However, we can be at par with other countries in creating a digital infrastructure which we can compare with best of the world.
And Rajiv, just taking from that, it goes to the next theme in this our session, which is this hybrid model. So obviously, this virtual hearings can't work for everything. There are situations where you do want to be in a physical court. And personally, after a year and a half of doing cross examinations by virtual sessions, I'm veering back towards wanting to be in the same room as the witness. In the beginning, I was very thrilled with how it was going, but over the course of the year, even witnesses and counsel have figured out ways to get around this. And anyway, I feel there's some set parts of a dispute where you need to be in a physical room. So that's where we bring in a hybrid model. Now, is a hybrid model really workable? Sidharth or Abhai, do you want to tell us? Like, how would it work? Do we do it stage-wise in a hearing, or do we do it alternative days as some courts are doing?
Yeah, Ira, that's very important. Because virtual hearing, or the e-courts which have been started, there's no stopping to it. It cannot be stopped at this stage because the type of infrastructure development it has introduced to the judicial, justice delivery system across India. Particularly the digitization of records. We are talking about the Supreme Court or High Court. If you look at it, digitization has started happening long time back, but there are huge number of 600 district courts. And if you go down there, many of them are still under the process of getting the records digitized. So that cannot be stopped. So virtual thing in any case is something which need to be promoted, so that at least infrastructure development gels with the whole structure. But then at the same time, there is an issue when we look at it again, High Court and Supreme Court, probably judges, the lawyers, even the clients have adopted themselves on the virtual hearing, though all the glitches which has been identified by Sidharth is there. Apart from that, there are many other glitches. Like for example, if we take a Delhi High Court, is still, right from the beginning, it was only the extreme urgent cases which were being taken up. So that means large number of cases were not even being heard. Then slowly it has been, the definition of urgent cases being enlarged, and multiple number of cases being started taking up for hearing. But still today, we have, say, only the cases filed in 2021 are being heard. So the court keeps 2021 list, and then there is at the end of the board, if there's some time left, then 2020 cases can be taken up. Mostly it doesn't happen. We've seen only 2021 list itself exhausts the entire court time. So if we look at beyond 2020 cases which are filed, I mean, before that, there's not even have come up for the last 1.5 years for a hearing. So that's the speed has I mean, that's taken toll on the disposal itself. So that there are discrepancies, but I mean, there are difficulties related to that virtual hearing. But then at the same time, physical hearing also is something which we have to look for, because may not be once these technological or infrastructure developments come to a particular level, then probably these glitches can be taken care of. But then again, if you go to the lower court, there still we cannot get away with the physical hearing there. They need to be, because most of the time records would not be available. There are many lawyers who get their business only from physical courts when they are present there. It's only in the metro cities when we see that lawyers are getting it, they work through emails, but not across India. There are a lot of issues there. So probably it's a hybrid model which is going to last for long. And in maybe the impetus which has been given to technological development at the lower court level, that need to be taken. I mean, give more interest. I mean, funds have to be raised, or more resources to be generated for that. It need to reach up to the lowest level, and at that stage, maybe it will be a mix of hybrid and mix of virtual and physical, which is hybrid, is going to be the future for us for a long time.
Thanks, Abhai. And actually, sorry, go ahead, Sidharth. Yeah.
If I could just add to that one bit, because you started by saying that you have actually started going back to a physical mode when it comes to examination and cross-examination of it.
I haven't actually, but I've started wishing for that mode.
Yes, which is a sentiment I share, and I am a strong proponent of the view that hearings for recording of oral evidence should be conducted in a physical mode as and when feasible, because that will ensure adequate and proper opportunity to the parties. I am all for a hybrid mode, different stages, yes. Procedural hearings can be conducted virtually. Case management hearings can be conducted virtually. Other stages can also be considered depending on the size of the matter and the extent of aid and assistance which you require from your colleagues, which you're required to give to the briefing counsel, senior counsel, etc., etc. But why I say cross-examinations, recording of evidence in a physical mode? Because you see, a matter which is fact-intensive, and there are multiple documents filed by both sides, it is difficult to cross-examine the witness and to confront him with documents or to explain the relevance of the question and the document to the tribunal, right? Tribunal may find it difficult to judge the demeanor of the witness during video conferencing. Tribunal members are also sitting in different locations, and this will impede their ability to consult and deliberate with each other. And as I have seen, my experience, cross-examination is a process which depends on the verbal and non-verbal cues which are revealed by the witness. But when you have this lack of audio-visual clarity, a virtual hearing does not always allow to, promptly and clearly catch those cues. And there are also concerns, how does one ensure that witnesses are not being instructed or tutored, something which you said at the inception when you asked this, when you posed this query. And deliberations and consultations for passing of necessary instructions between instructing advocates and senior counsel, unlike a final hearing where you can actually prepare your oral arguments, etc. In a cross-examination, your next question depends on the answer which the witness has given now. So all those things become very difficult. So that's my take so far as recording of evidence is concerned. Otherwise, virtual hearings are the way to go.
And
I agree with Sidharth, particularly on recording of evidence. We've done some, but it's highly ineffective. It needs a physical presence of witness, and the counsels is very is very important to be there physically.
Yeah, Sidharth, particularly your point on in a cross-examination, if the witness is tutored, that's a major risk in terms of overall proceeding. So cross-examination absolutely cannot happen online.
Absolutely.
But it's at least while this pandemic has gone on, we've kept these arbitrations going. So it's good that they haven't stopped it. So right now we're just talking about in the future an ideal situation. Also in arbitrations, we would do in international arbitrations, virtual cross-examination. For example, if the witness was in another country and it was just not worth it to bring him down and everybody agreed. So I think it's a case-by-case basis, but yeah, we can agree that there are some aspects of virtual which should stay and some which maybe can go back to being physical. Let me ask Sujeet the next question, because he's been very quiet. Sujeet, do you find, I mean, there's been a huge reduction of cost, or has there, because you're no longer flying your lawyers in first class and 5-star hotels to travel for their cases, right? Or has there not been this reduction in cost?
Yeah.
Thank you very much.
You have raised a very, very interesting question. And so, it has given all of us a smile.
Wishing happy Ganesh Chaturthi to everyone on this call. And thanks so very much. No, I mean, I will a little quiet because I wanted to speak Ila on a little different issue. So I thought I'll reserve my energy for that. But I think it's certainly a fresh energy. There is no question that the virtual hearing and the e-courts is a revolution we have seen, and it will and it should continue. And in fact, when the time is right, I want to focus a bit more on how do we sustain this. Quickly, my verdict on both. I think physical and virtual both has to exist. In fact, if we have to move India to next level, in my opinion, the virtual hearings are very, very important. Coming to the council and the logistical questions, Ila, you asked, it is good. There are different ways to manage challenges as far as the councils and the costs are concerned. And we at a time, as a client, put a lot of pressure on the AORs and at a time even councils that now that it's virtual, you need to pass on the benefit to us. Which will continue, and there's nothing wrong in that.
Well, does anybody else want to tell us their experience?
Can I pitch in? Yeah.
Sure, please.
Yes, in fact, to some extent, I think cost reductions we can see through. The virtual hearings, the travel cost definitely is down, because I'm not traveling and we are not flying the councils to the other cities. To that extent, the cost saving is there. However, I've seen some, mid-level councils, junior councils have also reduced their, the fees for virtual hearings for outstations. However, very senior councils have not yet, That
will never happen.
So there's still outstation charges are the same as it used to be. I hope the things will, settle down and cost will come down.
So let's just talk about this backlog, because a lot of people have spoken. Samir spoke about how one of the issues is that we're not getting final hearing on complex issues, right? What we're getting now from courts are interim orders getting passed. And I think even Abhai spoke about this, that we're at 2021 cases, 2022. So the backlog is actually far from reducing, it's getting more and more. How can we use this new platform that's been offered to us to do something about reducing the backlog of cases in court? I mean, does anybody want to, jump in here and take a? And,
if I can, jump on that.
Please.
Before I get into that, I just wanted to, speak a bit about the justice and want to set the context from my perspective. See, justice is actually a constitutional service. Every country owes to its citizen is what is actually the justice. Unfortunately, if we see the pendency of cases, across High Court, Supreme Court, District, and some statistics says around 4.5 crore cases are pending as on date, and every year we are ending at least 20%. Now, this is just we're talking about the court cases. We are not even counting here the FIRs pending in various police stations across country, right? So if we all add all that up, I think it's a huge disservice to our citizen. And I quote someone was I read somewhere that the pace at which we are continuing, the pace of clearing the cases, it may take 365 years to complete all the pending cases in the country, right? So this means obviously we have a big issue on this front, and in my opinion, the digitization can offer a huge solution. The pandemic has taught us that how digitization can accelerate, and I believe that in India, the justice system delivery also the digitization has to kick in. The incremental effort or the incremental work towards clearing this backlog, in my opinion, may not help. We will actually need a blockbuster reform. Now let's look at the other systems which in India has worked very, very well when it comes to the digitization. Let's talk about the Aadhaar, right? In 10 years, look at the revolution what the Aadhaar has done in the use of Aadhaar. Okay, income tax filing, e-filing, GST, right? It can go passport system, go on and go on. So, and this is a very, very important point, and this is the heart of what I want to talk about. Is basically if this is what technology can do to this country, why can't the same technology do to the justice delivery system in India? I think the pandemic has taught that to us. It has been imposed on us, and let's say that I talk about myself and everyone else as a legal system. We are a little slow to be very honest with you, in adapting to the technology. I think we need to use this the technology adoption. Okay, and today when it takes about 10 years to close the cases, I think we have to bring from 10 to 12 to 18 months. This means what we are talking about is that the technology for the justice has to evolve to such an extent, right? By in fact tenfold, in my opinion, over next 10 years. How can that happen? I think the physical and the digital both has to continue. I would even go to the extent of saying we should have a digital courts. There are two fundamental problems in a digital delivery system. The one problem we have is the vacancy and all that, correct? Even if we do all that vacancy, it may solve, in my opinion, the 10% of the problem. The 90% of the problem, whereas, let's say from 10 years, it may come down to 8 years. But from the 10 years, if you want to bring it to 12 to 18 months, then we need to have the digital courts. For example, we have brilliant retired judges, right? Now, if we allow the digital hearing from home, if we allow the retired people to conduct the hearings from home, then suddenly what all this can do is basically this can completely change our delivery system. So in my opinion, we should look at these efforts very, very closely, and we should also connect this digitization of the courts. Now, I agree with Sidharth when he said that everything can't be done digitally. I agree with you. But I believe 70-80% of the work can happen digitally. If we do that, this will not only help us in the ease of doing business, but this will also help us achieve our Prime Minister's vision of India achieving the $5 trillion economy. So digital has to play a very, very big role. And honestly, I think the Legal Era is one of the best platforms I have seen in this country. I think this platform, and we can partner with the Legal Era, all of us as a fraternity. My biggest question and the challenge which comes to my mind is how do we sustain this? My concern or my fear is we have seen so much of benefit of this. But what if one fine day the 100% attendance starts in the courts and we all rush back to the physical court and we forget the digital court? I think that should not happen. If honestly one plea which all of us can take on this session is basically in what form we can contribute to sustain this digital revolution in courts, what we have seen in this country. Over to you.
Yeah, can I comment here, Ila, if you allow me?
Please.
I echo the similar kind of emotional expressions which Sujeet, is expressing. We echo the similar kind of, because as client, we are the frustrated lot. So we have a similar kind of emotions. But then let's be practical here. Sujeet mentioned 3.5 crores cases. Now, these 3.5 crores cases, and if we just analyze these cases, we will come to know that perhaps one judgment can resolve hundreds of cases, because the cases are of similar nature. There are, in 3.5 crores cases, you will realize that there are millions of cases which are 138 cases, or there are millions of cases which are of the same nature, deficiency in service or defective product or similar kind of situations. Now, When we say that this is a revolution, because it's in the start of a revolution, we say that the next step should be the use of artificial intelligence in terms of dealing with these cases. If you have a predictive modeling, and on a predictive modeling based on artificial intelligence, that yes, these number of cases or similar number of cases based on the previous precedents, this would be the outcome. Ultimately, court would have the discretion at the court level would be too minimum, and you will not have inconsistency in the court decision making. There would be consistent approach. This would also help in one more way. Out of these 3.5 crores cases, maximum cases are the government filings. Why do government file cases? For the simple reason that somebody should not be questioning them that you have not filed cases and you are aligned with the party. Now, if with this mindset, cases are getting filed, there's a backlog of cases and the pendency would keep on increasing. But then if we use technology, it essentially means that all those cases before filing, you will have the machine learning models or predictive models. Based on that, you will say that no, the outcome of these kind of cases would only be negative or X or Y or Z. That kind of outcome would be there. At least you would be restraining people from filing those frivolous litigations or unnecessary litigation. That is where the technology would help immensely in terms of addressing the backlog of the system. Now, as a client, as a citizen, what do I want from the justice delivery system? I want a speedy justice. I want an absolutely reduced cost. I want a system whereby where the court's functioning, there should be a systematic functioning of the court, and above all, the functioning should be such that there should be faith in the justice delivery system. Now, if I analyze these 4 parameters, I think that today in all these 4 parameters we are failing. Do we have a faith in the justice delivery system? We would say, what faith we are talking about here? We were talking about the hybrid system. Now look at the situation. In a hybrid system, at least I should be having an opportunity of saying that no, if you are having a physical hearing, please don't give me physical hearing, please give me virtual hearing. Here at the courts, this is the mindset issue. Here at the court, they would say that no, we would not be giving you virtual hearing. You better come for the physical hearing. No, is this the hybrid kind of hearing we are talking about? Answer is no. These things are happening in the high courts level. Chief justices are passing those orders and not allowing virtual hearing to happen. Now, these mindsets need to be changed. These mindsets need to be changed so that we can, when I say that these 4 parameters are important, we can have that faith in the system that yes, there is an effort in terms of addressing the issues, resolving backlog of cases. And there, I completely echo what Sujeet was saying, that digitization, use of technology, that would certainly help in the times to come. And from an Indian industry standpoint, I think we need better technology and we deserve better technology and better infrastructure. Ultimately, we're all contributing to the economic growth of the nation. Thanks.
Thanks, Sanjeev and Sujeet, for those recommendations. And clearly you feel very strongly about it, and you're right on many points. Artificial intelligence being used to ward off potential litigations, I don't know about that. That's taking away our bread and butter. So I'll just reserve any comment on that along with Sidharth and Abhai. But of course, you're right. Technology and artificial intelligence is the next way to go. And yes, honestly, we need a lot of funding into various parts of the country to remove the backlog, because right now we are talking with some big companies, partners from big law firms, and the kind of disputes that we see, we are able to get these over to our counsel and heard in a court virtually without much problem. But the vast majority of the backlog aren't those cases and aren't those litigants. So, but let's go back to our kind of the cases that you would be dealing with. Now, one of the things that I think we've seen is that arbitration, as opposed to litigation, has been dealing with virtual hearings and technology in a much more seamless and effective way from a lot before the pandemic started. It was already a very natural way to go in arbitration, to have these e-hearings. So is this something that as a client is going to push you more in the next, based your experience the last year and a half, to maybe start thinking about moving more of your disputes into arbitration? Like when you draft a contract, you're going to think about it and say, maybe let's get an arbitration clause in and not leave it to the court?
Yeah, arbitration is actually money-making machine. I know that I may be making a controversial statement, but so be it. Okay. Unfortunately, one of the reasons why the arbitration has failed in the country is because of the cost involved in the arbitration. Can you imagine that today I have to advise my team, across here or in the last organization, I have to tell them if it's not a very, very significant issue, I can't arbitrate. It is cheaper for me to go to court and litigate, right? So if the alternate dispute resolution has to honestly work in this country, we have to have a system whereby there is a cap on the fee. There has to be a method. I mean, there are situations where we have come across arbitrators and they don't want to adhere to the schedule set. They want to set their own schedule of the fee beyond what is prescribed in the. I understand it's a guidance, but there has to be some rationality to that. So this is the reason, in my view, arbitration is fantastic, is effective. Mediation is the machinery is not effective. The people who are running the mediation center, specifically the courts and all that, it's not effective. I heard, I think in the early afternoon, Justice, I think Mr. Chandiok was talking about that we are expecting the new mediation law. Let's see what is that in the offer. But if that has to work, it has to become a very, very cost effective. Otherwise, I've been staying away from arbitration for one of these reasons.
Does anybody else want to jump in?
Well, the arbitration, you have raised a completely new topic, in a way. I would say that, and that too, you are asking general counsels and in-house counsel. We are the frustrated lot as far as arbitration is concerned. We have experienced arbitration for the last 2 decades, and all that ultimately it's all imposed arbitration, that too ad hoc arbitration. And with that, retired judges and time-passed lawyers, how can we be giving any positive comment about it? Well, it's an absolutely frustrating experience. So
actually, I didn't mean to go completely off topic. I only meant in terms of technology, that arbitration had already incorporated the technology that litigation is now picking up in terms of e-hearings.
From that standpoint, Ida, I would say that yes, the online dispute resolution mechanism would be another revolution in terms of addressing the issues of corporates or the industry. And I think we need to promote that. But then this online dispute resolution can only be promoted when we have a reliable, credible institutional framework here in India. The moment we have that, I think I'm not talking about the large, high-stake arbitration matters. Perhaps that might be, and they may require a different treatment. But then as far as the normal litigations are concerned, normal disputes are concerned, I think online dispute resolution mechanism, which would be another revolution, which, number one, industry deserves this, that industry should have this infrastructure. And I think that would be largely successful, Let's see how it goes, how to what extent we come out with those kind of credible institutions who can offer this kind of mechanism. But ad hoc arbitration, we all have absolutely, I think, negative comments on that. Yeah.
So if I could just add my bit to it. So definitely I would say there is an increased leaning towards alternative dispute resolution mechanism, but the precise role of technology, I would say, is not well documented. And without much data to back this, technology would have a great role, since this would enable parties to agree on procedures which are more flexible, something that would not be possible with traditional court-based adjudications. However, more than technology, it is the time-bound nature of these mechanisms which attract companies, which is what I feel. End of the day, every company wants to ensure that its core functionalities are continuing without disruptions and legal expenses. And a great example would be the Singapore International Mediation Centers, RMED, RCLOS, which has had a great reception. And just to give some statistics, because Dr. Gemawat and Mr. Jain have been very vocal, and I share that sentiment and I understand the frustration. But as per one estimate, courts take an average of 1,445 days to resolve disputes. ADR takes 730 days and ODR takes between 45 to 90 days. So therefore, the changing mindset is natural and the figures speak for themselves.
Absolutely. No, just to interrupt here, in a normal court proceedings, how many days you would be considering for the cross-examination? 5 days, 10 days, 15 days, 20 days, 25 days. But then in arbitration, and that too ad hoc arbitration, believe me, even the cross-examination would take 60 days and 80 days. And that
Okay, Sanjeev, you obviously had a particular experience, and
no, we all have these kind of experiences.
And Dr. Gemawat, we would rather leave this for the next session, which is
I think the next session,
conducted by Tejas Karya.
We're actually running out of time, and the next session, I think they're waiting. But just any last thoughts, if anybody would like to just tell me what is it that you think we can do to make virtual hearings lasting beyond this pandemic and sort of bring them on par with physical hearings. Is there any last thoughts that anyone wants to share?
I'll take that very quickly, Ila. I think I spoke a lot about it. I think one thing is that this has to sustain. The digital has to sustain if we want to liberalize the system. That's point number one. Point number two, the digital infrastructure has to, as far as the e-courts are concerned, it has to become 10 times better. Let me say that, and let me say that we have much more than that in this country in terms of capability and technology, which we have seen with Aadhaar and a lot of other services. So we have to make it work. And three, we should also think about the system whereby even the retired judges can work digitally. There can be a separate tribunal depending on the subject. In fact, you can do so much of niche, so much of specialization when it comes to conducting digital trials. You can do subject-wise with the data protection coming into picture, the complex technology issues coming into picture. So therefore, we have to ensure that we don't lose the plot.
Yeah.
Thank you.
Yeah. Can I?
Sure, please, Rajiv.
Yeah. I think there needs to be to make this virtual platform work as an alternate hybrid system. I think there should be some uniform guidelines issued, that different courts are taking different type of procedures. So that needs to be, there needs to be some uniformity. And then we should, as I said in the beginning, we should look at this as an independent system rather than an arrangement imposed on us in COVID pandemic. And there should be some criteria laid down, what can be, which are the type of issues which can only be taken through the physical, and what can be done through virtual. If these things are streamlined over a period of time, I think we will have a very fantastic system of a hybrid model working in this country.
Ila, Sidharth, there is actually just 31 sentence. There is actually an opportunity for digital specialist counsels and lawyers who know how effectively, I'm telling you, it will emerge, and we need that more, whereby I see a huge opportunity once the system explodes, whereby law firms will have the people who specialize more in managing the digital trials and digital sessions.
You mean more technical, people who are technologically savvy?
No, I'm not talking about TMT law. I'm talking about the people who will be very, very apt in conducting the digital arbitration. Let's say I'm assuming that we will have a system whereby certain kind of cases or certain levels, certain stages of the hearing will move permanently to a digital. And in that scenario, we will need a specialist people to do that. Like, Sapan in the earlier session made a very good point that we will also need a full-time arbitrators who are available, who are not practicing in courts, who are available for the full-time arbitration. That's how the digital arbitration will also work.
Ira, I would just have a last comment very briefly.
Sure, please.
Technology is bound to evolve. Technology would be impacting us, and technology would be impacting us positively. History suggests that. So it is bound to come. It would be impacting us. What three things would be required, in my view, is create proper, appropriate infrastructure, train people, and develop discipline. I think we are through on this. Fact remains, 10 years down the line, lawyers' offices would not be the offices with all those physical documents. Lawyers' offices would be the technology office only in terms of all that digital infrastructure. So I think, and that's what we need to create, and perhaps we would be creating that in the times to come.
Okay. Thank you. Thank you, everyone. This was really a lovely conversation, and thank you for all your views. I completely agree with you that the hybrid model is the way to go, and hopefully we're going to see a lot more of it emerging in the future. And thank you to Legal Era, and once again, thanks to all our participants.
Thank you very much.
Thank you. Thanks, everyone. Bye.
now has a clearer perspective, I would say. So panel and Ela, thank you so very much for discussing the nuances of e-courts and virtual hearings with your expert and witty takes. Must say thank you very, very much.